Today we're going to be talking about gun laws, not today, not last year, but at the time of the founding of the United States. Hello and welcome to Talks on Law. I'm Joel Cohen. Today joining me on this historical gun rights, gun law journey is Professor Darrell Miller of Duke Law School, who is the co-director of the Duke Center for Firearms Law. Darrell, it is a treat to talk to you today.
Happy to talk to you, Joel.
And we're talking about gun rights and gun laws at the founding. I guess first off, when are we talking about?
Well, if you look in the historical record, there's going to be regulations on things like the militia. There's going to be regulations on storage of gunpowder. And then there's going to be some kind of regulations that are legacies of the English common law, like requirements that people keep their guns away from fairs or markets or in the presence of the king's ministers, the government ministers. Those are all the kinds of laws that are on the books around 1791 when the Second Amendment is ratified.
So am I right that at the time of the founding, we'd be talking about state laws that regulate guns? There wouldn't have been a federal gun law.
The federal government, except for the militia, does not get in the gun regulation business until the 1930s about. So most of this is state regulation.
Let's get into the weeds. Why don't we have a couple of examples of the laws that did exist at the time of the founding?
Right. So one important and really interesting one is a law from North Carolina in the 1700s. It's almost contemporaneous with ratification of the Second Amendment in 1791. And this essentially just cut and pasted an old common law era English regulation about prohibitions on guns in fairs and markets or in the presence of the king's ministers. This was a statute that was known as the Statute of Northampton. It was passed under, I think, the reign of King Edward III, and essentially its language is just cut and pasted into the North Carolina law.
What did North Carolina do when it came to the king's men? Did they replace it with something else?
Yeah, I think the premise was that when the Statute of Northampton is essentially transposed into the modern era, it's not about the king's peace anymore, right? So this is a peace provision. This is about keeping the peace from sort of quarreling groups. It's about the people's peace. That is, it's the common peace that belongs not to the sovereign, but to the people as sovereign. This is a part of a larger and interesting area about the nature of the peace and who gets to keep the peace.
Well, I can imagine there's also a number of current gun laws that certainly did not exist. I'm thinking of technologies and places that weren't around at the time of the founding. Maybe you could walk through some examples that exist today of gun laws or gun regulations that would not have existed at the time of the founding.
Right. So, obviously we live in a completely different world in terms of transportation, in terms of society, in terms of, the size and congestion of cities than they did in the 1700s. So, a prime example that I often think of is it really wasn't until the 1960s that the federal government got in the business of prohibiting guns at least loaded guns in private hands in the cabin of a jet airliner. Obviously, you're never going to find a gun regulation about jet airliners in 1791 because there are no jet airliners. So this is an incredibly significant and important set of questions now that the case called New York State Rifle and Pistol Association versus Bruen has been decided, because Bruen says that the constitutionality of a regulation by how traditional it is. And, if you talk about, well, what is the tradition of prohibiting guns on airplanes, and you have to go back to 1791, you're not going to find anything. So what this suggests is these historical laws that existed in 1791 or thereafter are going to have to be understood not about are they about airplanes, but what is the purpose behind them in thinking about where guns might be restricted and in the modern era.
So there may be an analogy approach where it's, okay, if as you mentioned, fairs and markets were seen as overly congested and therefore perhaps a dangerous place to discharge a firearm, well, by analogy, perhaps a sports arena would fit.
Absolutely. I mean, that's, I think, the kind of work of analogy that's going to happen in the post-Bruen era. And just to be clear, I mean, in Edward III's time, we're not talking about firearms. We're just talking about swords. We're talking about armor. But the dangers of weapons in congested, crowded areas is totally exacerbated by modern technology, where, as we saw in tragedies like Las Vegas, where you don't even need to be in the crowd to actually be able to rain down.
The shooter was in a hotel room,
Yeah,
adjacent.
the shooter was in a hotel room, above a crowd. And so the modern era is going to have us really have to think about what are these purposes for these historical regulations, and how do they map onto our modern kinds of problems, like people taking guns in airplanes, like people taking up sniper positions at outdoor concerts, and so forth.
You mentioned that after the Bruen case, Second Amendment analysis or gun law restrictions have to be viewed with this text history tradition test. What is the window of time that's relevant under that test? Is it just at the time of the founding, or is it at the time the specific amendments were ratified?
Well, that's a really important and kind of hotly contested set of questions. So the case law, as it's developed, and in Bruen itself, is not clear about what is the relevant dates. It could be 1791 when the Second Amendment is ratified, or thereabouts. It could be 1868 when the 14th Amendment is ratified, because the Second Amendment applies to the states through the 14th Amendment. It could be some kind of an amalgam of time between these two dates, or even longer, just so long as the same kinds of regulation is sort of in place. So we don't have a really concrete answer to that question, like what is the relevant date? We've got some sense that some kinds of laws are going to be too new, and therefore are going to be suspect because of their novelty. But even in those circumstances, there might be an opportunity to say, well, this modern regulation, like a regulation on a gun in an airplane, is similar enough to a historical regulation that it forms part of an unbroken tradition.
Interesting. So and I haven't read all the laws that you have listed in this repository of ancient gun laws that you have on your website, but if there was a law that said you're not allowed to bring a cannon on a ferry, then we might be looking to a law like that to try and understand bringing a gun on an airplane.
Right. So, I mean, there are actually regulations in the repository about, shooting guns off the decks of riverboats, for example. And so what we're going to find out in the future is that close enough to a prohibition on a loaded gun, in the cabin of a jet airliner, to support a tradition of keeping guns out of public transportation or out of dangerous places like, airplanes.
Darrell Miller is a professor of law at Duke Law School and the co-director of the Duke Center for Firearms Law. What a fun conversation looking back at these laws and learning how they're so newly relevant today.
Thank you.